Hi Neha, would it be a while for the students to join? I have a meeting at 4 o'clock today.
No, we are good to begin it now.
Acha, okay.
Okay. So, respected Principal Sir, Dr. Gaurav Khan Sarogi, Vice Principal Sir, Dr. Sunil Vivedi, Speaker for today, Advocate B. Ritika, Reddy Ma'am, all the faculty members and the students. Good afternoon to all of you. I, Neha Upadhyay, welcome you all on the behalf of Sri Aurobindo Institute of Pharmacy. We are organizing this workshop as an activity.
Meeting at 4 o'clock today.
No, we are good to begin it now. So we are organizing this workshop as an activity under institutions respected Principal Innovation Council. Dr. Gaurav Khan Sarogi. Okay. So we are organizing this workshop as an activity under Institutions Innovation Council, established by Ministry of Education, Government of India. World Intellectual Property Day, as we all know, is celebrated on 26th of April. This event was established by World Intellectual Property Organization, that is WIPO, in year 2000 to raise awareness of how patents, copyright, trademarks, and design impact on daily life, and to celebrate creativity and the contribution made by the creators and innovators to the development of societies across the globe. Today we have with us Dr. B. Ritika Reddy, who works as a Senior Associate IP in GSLC Delhi. Advocate Reddy is an alumni of National Law University, Tamil Nadu, Trichy, and member of Bar Council of India of Madhya Pradesh. She is specialized in trademarks, copyright, industrial designs. We are glad to have Advocate Ritika in our institute to explain today's workshop. Now I hand it over to Ritika ma'am. You may conduct the session. Hello, ma'am. Ritika ma'am, over to you.
I am so sorry. I think there was some issue with my network. Am I audible?
Yeah, you're audible.
Yes. Okay, I'm just sharing my screen. Hi, everyone. Thank you so much, Aurobindo Institute of Pharmacy, for having me. And on the account of World Intellectual Property Day, I wish all of you, and let's hope that today's workshop is beneficial for all of you. And I'll be very happy to answer any questions in between. Yeah, okay. So talking about startups, there are a lot of things that we need to keep in mind when it comes to intellectual property, right? So before we start, let's just understand what intellectual property means in a very basic manner, right? So intellectual property is comprised of two terms, intellectual and property. Now, intellectual, a very basic meaning, intellectual means anything which arises out of your mind, an output of your creativity, okay? And property means anything that you own, anything that belongs to you, all right? So intellectual property, depending on the law, so there is an intellectual property law And under that, there are various acts. And depending on your idea, it falls under a certain category. So there is a literary work, artistic works that falls under the copyright regime. Then there are trademarks, there are designs, patents, and several other types of intellectual property. Now, intellectual property is such a broad domain, and it is changing literally every minute, right? So there are several types of intellectual property, but today, due to the constraint in time, we'll discuss about the main types of intellectual property, that is patents, trademarks, copyrights, and designs. Now, the most common question is, why do we need intellectual property? Why is it that we need to secure intellectual property? Now, intellectual property, when it is, so when you associate yourself that, okay, let's say my creation is protected under IP, you automatically, your product or your creation gets a sense of credibility and authenticity, right? So automatically your idea or your invention, it sort of gets an identity in the market. Okay. The other one is an incentive that intellectual property gives, converting your ideas into a profit making asset. So that is something like an incentive that is given to a creator. Now, intellectual property, like I said, once you get an identity, for an example, you buy a land, right? When you buy a land, how do you know, how do you prove that this so and so land belongs to you? That is through a documentation, through an official procedure that goes on. That's how you claim an ownership over that land, right? Similarly, intellectual property at the end of the day is a property. Okay, so you become an official owner, and that's how you become that's how that property becomes an identity on its own. Okay, and then lastly, protection against the potential infringers. Now, an obvious point that tomorrow, if, let's say, God forbid, if your idea or your creation gets stolen or it's copied by a third party, so you do have a protection if you have safeguarded your intellectual property. All right. Now, let's talk about a bit of the rankings in India particularly. So despite the measures taken by government, despite all the subsidies that are given to startups, still India is far behind when it comes to compared to the other countries when it comes to the filings, right? So over the past few years, China and US has been on the top when it comes to IP filings, especially patents, right? Now, China has been on the top position, number one position, since the past 4-5 years. In 2021, despite the pandemic, China filed close to around 7 lakh patents, and US was 4 lakh patents in 2021, as per the WIPO data. Now, WIPO is World Intellectual Property Organization. As per that data, China and US has been leading when it comes to the filings. And in 2021, India is still on the 9th ranking when it comes to patents and 6th when it comes to trademarks, right? So in order to promote that IP culture, we need to be more aware of our rights, of the fact that we need to file our IP in order to safeguard it, in order to get it in our name, in order to enforce our right. Okay. Talking about the administrative framework in India. So intellectual property has basically 5 offices all over India, that is Mumbai, Delhi, Kolkata, Ahmedabad, and Chennai. For Madhya Pradesh, the jurisdiction falls in Mumbai when it comes to trademarks. For patents, it's Kolkata. For designs, it's Kolkata again. And for geographical indications, it's Chennai, right? So this is a basic of the administrative framework in India. Let's dive into the major types of intellectual property. Let's talk about the first one, that is the trademarks. Now, trademark, it's also called Vyapar Chin in Hindi. Now, trademarks is basically an identity of your product or your service. Now, when you look at your phone, okay, just look at your phone. How do you know that this phone belongs to Samsung or Apple? It's because of the created the way the product is created, the logo attached to it, or maybe the name that is written on that. So that particular identity is called a trademark. Now, trademark can be of any type. It's the most commonly seen trademarks is logos. You obviously see a lot of logos around. Then there are the words, for instance, Toyota or maybe Mercedes. Just the word per se is a trademark. Now there are a lot of companies which are coming up with a different sort of a trademark, like sound trademarks, or maybe shape trademarks, like Coca-Cola bottle, for instance. Now the Coca-Cola bottle ka shape, when you look at it, you automatically know that this bottle belongs to Coca-Cola, right? So that shape also is a trademark. Nokia's jingle, when you listen to the ringtone of Nokia or the Apple, you know that, okay, this belongs to this company. So trademark is basically a source identifier, which basically tells you that, okay, this product belongs to this company or this brand, right? So like I said, trademark, it differentiates one person's goods to the other person's, and it can be of several types. Let's talk about the procedure of filing a trademark in brief. So the first step, and I believe the most important step, is the trademark search. Now, a lot of people, they tend to neglect that step because, directly file kar dete hain. So that is not what is, that is not what should be done ideally, because the whole process, it involves a certain, money, right? So trademark search at a very nominal cost, when you get it done, you kind of know that, okay, before proceeding further, I need to take these steps, right? So trademark search is basically when you search for a trademark in the journal, okay, you look for the availability of a trademark to see if this is available in the market, if there is any problem with your trademark. Let's say you have a trademark and that trademark is already there in the market, and without knowing, you just file the application. So tomorrow, to avoid that refusal from the trademark office, you need to conduct this search, ताकि आपको पहले ही पता हो कि, okay, this trademark is already there and we cannot file this. So you have the time to change the trademark, to amend the trademark. Okay, so that is the first step. Second step is filing of the application. And once you file the application, you get a number that is called an application number. Now, the trademark application can be filed either offline or online. And the fee difference is very nominal. Then after when you get the application number, the application goes into examination. Now, this examination stage, the trademark office examines your application, sees if there is any problems with your application. It can be any procedural problems, or it can be any problem with your mark. If the office feels that this mark is similar to already existing trademark, they issue an examination report. Okay. Once that is done, once they issue a trademark report, you need to reply to that examination report within 30 days. And after that, if that reply satisfies the trademark office, the trademark goes into advertisement. Now, advertisement is where third parties, basically the public, can review your trademark in the trademarks journal to see if your trademark is similar to them. So first is what is analyzed or examined by the trademark office, and then it is the public. Okay, so it is sort of two-staged. Now, if they feel ki, okay, your trademark is similar to their trademark, so they can oppose your trademark. That is called an opposition stage. Once that is cleared, the trademark goes into registration. See, there is the whole procedure of from the filing till the registration. It takes around 8 months in cases of direct. In direct cases, right? If there are any oppositions, it can take even longer. Now, this, I am sure the two symbols that you see here, most of you would have seen it very, often. Now, if you see any mark jiske side mein there is a TM written, so understand that that is a pending trademark that is not registered yet. And when there is an R, it denotes that it is a registered trademark. Okay. Now, you cannot use a very obvious fact that you cannot use you cannot use R when your trademark is pending registration. That amounts to misrepresentation. So yes, so that is the difference between TM and R. The validity of a registered trademark, once your trademark gets registered, it can be renewed for 10 years and then further 10 years. So this renewal period, you pay a renewal fees every 10 years for an indefinite period of time. Okay. But if you do not renew it within the stipulated time, the trademark gets abandoned. Okay. Talking about the next type of a trademark, that is the copyright. Now, copyright is a type of an intellectual property which I believe a lot of us unknowingly, infringe copyright. हम कभी we share photos ऐसे ही कभी Facebook पे हमने share कर दिया without giving credits to the creator, right? That is a copyright infringement. So copyright, it simply means right to copy. Basically, copyright is a bundle of rights. It is a group of rights that is given to an author or an owner, like maybe to, they can basically do anything with their work. Let's say if I create maybe I create a novel. Okay, I write a novel. So I can either license it to a filmmaking company, right? They can make it into a film, or I can translate it into a different version. Maybe I wrote it in Hindi, I can make it into, I don't know, maybe like English, or I can convert it into Bengali. Okay, so I can communicate it to the public. I can convert it into a play. So basically, copyright is a right that is given to an owner to make it, to use it as they want it to be. Okay. Now, copyright. Sorry, 1 second. Yeah, copyright are basically divided into several types. There is artistic works that include your photographs, paintings and sculptures. All of that falls under the artistic work category. Now, there is other type, that is the literary work. For instance, novels or your stories, or anything that you've written, right? Or research papers. All that falls under the literary work category. The third one is dramatic works. Now, if there is a play that you've written or a drama, that falls under the dramatic work category. There is musical works, then there is sound recordings, cinematographic works, and computer programs. Now, computer programs, a lot of people, they actually confuse it ki computer programs will fall under the patents, but it actually falls under the copyright regime. Okay. Now, the procedure for the copyright filing is pretty basic. There is no search as such like it is conducted in trademarks. So once the application is filed, the application goes into the examination by the Copyright Office, and then subsequently it goes into registration. Okay. Now, copyright is actually automatic. Once you create a work, you automatically get a copyright over it. The registration, the filing, basically, it's not compulsory as such, it's optional, right? The symbol that you see, the C, you can use it as soon as you finish a work. As soon as you complete a work, you can use this symbol C. But it is recommended that you file for a copyright registration, because tomorrow, if somebody copies your work, you have a proof that this work belongs to you and you can take an action against that person. If you don't have a copyright registration, right? So you basically, there is no proof, right? That, okay, this work belongs to me. So tomorrow, if you want to take an action, if there is an infringement, you can take an action against them if you have a copyright registration. Moving on to the designs aspect. Now, designs is also another, design is another type of intellectual property which is often confused with patents. Now, designs is basically an intellectual property which is concerned by the look of an article, by the look of a product. Now, if phone is created, the structure of the phone, the shape of the phone, how it is appearing to your eye, that falls under designs. Okay, so a lot of times, for example, I'll give you an example. Let's say there is a chair that was created. You create a chair, and the structure of the chair is very different. Okay, it's not like a normal chair. It's very different. So the structure, how the appearance, the basically the appearance of that chair can be filed as an intellectual property. Now the chair has basically, maybe the chair has some functionality attached to it. Maybe it has maybe like a seat warmer, or maybe some functionality attached to it. Okay, so that would fall under the patents category and not the designs. So always remember, design is always concerned with the configuration or the shape or the features, basically the appearance of any product. Okay, no functionality is ever associated with designs. Okay, so there are few criteria of filing a design. That is, the first is it should be novel. Basically, it should be something new and not already existing in the market. Second, it should have been created by an industrial process. Okay, and lastly, it must be judged by the eye. Okay, it is not, like I said, nothing functionality, only judged by the eye, the basically the aesthetic value of the product. Procedure of filing a designs. So the design search is basically conducted by the designs office itself. Once you file an application, there is an allotment of the number that is called the design number, and then it proceeds into examination, followed by the registration. Now the design process, the whole process, it's much more lengthier. I mean, of course, patents takes much more longer, but designs is somewhat similar to obtain registration, because there are a lot of formalities that are required by the designs office. And I would say the laws of designs is sort of ambiguous still. There are a lot of areas that we need to work on to get clarity over the designs law. Talking about the validity of designs, when you file for an application and you get it registered, the validity period is 10 plus 5 years. So after 10 years, you pay the renewal fees, and plus 5 years. So total of 15 years, your design is valid. And after that, the same goes into public domain. Okay, so you cannot claim ownership over your design after 15 years. So here is like a brief example of how what all can be considered as a design. So these are the few products which you can say that we can file a design application for. But if you see the cycle, this one wheel cycle, I'm not sure what is it called. So the structure of this cycle can be filed as a design, but if there is any, the functionality would not be associated with the same. Okay. Lastly, patents. Let's talk about patents. So patent is basically a monopoly right that is given to an inventor for disclosing the same to the state, right? So the criteria for filing patent is first novelty. It should not have been existing in the public, or it should not have been out there in the market. That is the first criteria. Second criteria, there should be an inventive step. Now, inventive step or non-obviousness. Now, basically, when you file an application, it should have been like that invention should not be obvious to the public. There should be an inventive step to it. As in, like somebody shouldn't say ki, "Arey, I could have made this. This is something this is very obvious. I could have made this." Now, this is a very, subjective sort of a criteria, but this is one of the essentials of patents, that your invention should not be obvious. Thirdly, it should have some commercial value. There should be some utility to it. It should have there should be some commercial return to it. Okay, there should be some use to it. Now, patents law under section 3 lists down what all does not fall under the patents category. What all cannot be filed as a patent? Okay. The first one is anything that is contrary to the natural laws. Now, hypothetically, it's a very hypothetical example, but if you create an invention which basically reverses the natural law, that does not file, that you cannot file as a patent. Anything that is creating or disturbing the public order, or causing any sort of damage to the living being, that cannot be filed as a patent. Any scientific principle, basically, for instance, there is a scientific, like gravity. I mean, obviously that is like long ago, but any scientific principle which is basically a discovery and not an invention. So there is a difference between a discovery and an invention. Now, any sort of discovery which includes any, if you find out some sort of a species of a plant or an animal, that cannot be patented. If you just merely mixture of two substances and then you say that, okay, you want to patent it, so that also cannot be patented. If you arrange few things, like for example puzzle, okay, you arrange it in a way and then you want to patent it, that also cannot be patented. Any agriculture or horticulture methods cannot be patented. And these are other list. Treatment of curing a disease, the treatment per se cannot be patented. The species of plants and animals, like I said, it's a discovery. Software or the business models, business methods falls under the copyright category and not the patent category. Any copyrighted content. And if you find out, if you discover or you invent maybe a method of playing a game, that cannot be patented. The way you present on information, like for example this PPT, you cannot patent a PPT. You can go under the copyright, but you cannot patent a presentation. Okay. Then topography of an integrated circuits and traditional knowledge. Traditional knowledge is basically, like turmeric, for example. Turmeric has been used as an antiseptic over the years. Okay, it's a traditional knowledge. So that falls under a very different, in a different intellectual property type, that is the traditional knowledge as such, but this cannot be filed as a patent. Now, any invention relating to the atomic energy also cannot be patented. Talking about the filing process of patents, the first and foremost is the prior art search. Now, prior art means existing knowledge. Now, here it is recommended that you take help from a professional, a patent professional, who can guide you as to how, whether your patent or your invention is maybe already there in the market, or maybe already filed by somebody, or is there any, procedural problems with your application. So prior art search is basically a very, very detailed analysis that is conducted regarding your invention. Okay, so once the prior art search is cleared, the patent goes, you can file for a patent, the patent application. So patent application can be filed as a provisional or a complete specification. Basically, provisional is a prototype, or maybe like if you have a blueprint ready of your invention, you can file for a provisional application. Okay. Now, within 12 months of filing a provisional application, you can file for a complete specification. If within 12 months, the complete specification is not filed, the patent goes abandoned. Okay. So the third step, the third step is the publication stage, where the patent gets published in the patents journal. And this is the months that you see here. It is from the date of filing. Okay. So from the date of filing till 18 months ke andar, it goes into publication. You can actually pay a fee and go for early publication as well. But this publication fee needs to be paid during the time of the filing. Okay. And then there is request for examination. Now, request for examination also requires a fee that needs to be paid during the filing. It's recommended that you pay during the filing when you file for the patent. So that the time period for that is 48 months. If there is no problem with your application, if the patent office feels that, okay, your application is good to go, either they schedule a hearing, and you basically the patent agent or maybe the applicant can attend and, convince the patent officer uh, regarding the acceptance of your application. And once that is cleared, it goes into opposition, like in trademarks. The opposition here, it can be done post grant and pre grant as well. Okay, so if there's no opposition received from the third parties, the patent goes into the grant, basically the registration. Okay, after the grant, even there is one more year that is available for opposition. If there is no opposition received within the 1 year of registration, then there is no problem as such, then nobody can oppose your patent. But then if there is a post grant opposition, then there is a separate opposition proceeding that goes on. Okay, now patents, the validity of patent is 20 years, and after that the same goes into the public domain. Talking about concluding with the remedies, what are the remedies that is available in case your intellectual property gets infringed? If somebody steals your or copies your intellectual property, what are the remedies that you have? Now, basically, broadly, you have civil remedies and then there are criminal remedies. Now, civil remedies there is injunction. Basically, a court puts an order against the infringer or the somebody who stole your intellectual property. They put a stop to them. They said that, oh, you cannot sell this product anymore. That is injunction. Second one is damages. Now, damages is you claim the amount of loss that must have been caused because of that person stealing or copying your work. Okay. It is recommended that we go for injunctions as soon as you feel that, okay, not just, as in if you come across any infringement against your intellectual property, you go for an injunction. Okay, that is an immediate what you call a remedy that can be taken, because damages will take time. You have to prove that, okay, this much damage has been caused, this is my goodwill has been hampered. So injunction is an immediate, a much more faster remedy. So these are the two civil remedies that is available. And the second one is the criminal remedy. Now, criminal remedies is usually enforced for a much more serious infringement, specifically in cases of counterfeits. Okay, in cases of counterfeits, the criminal remedies is the police, there is involvement of police. You file an FIR, there's a warrant that is given, that the warrant is issued, and then police can raid the infringer's place and take up all the infringed material. There is a fine, involvement of fine, imprisonment involved in criminal remedies. Sorry. So these are the two basic types of remedies. And if there are any questions, I'll be very happy to answer. Thank you so much. Thank you.
Okay, so do we have, thank you a lot. Thanks a lot, ma'am, for your session. Do we have any questions? Students are free to ask any questions if they have. Okay, so we have Avni Jain. Avni, you can ask your question.
Hello. So my question is,
Yes.
what is the cost of filling a patent in India?
Avni, I can't. I think your voice broke in between. Could you please repeat the
Okay.
question?
So my question is, what is the cost of filling a patent in India? Like, what is the exact cost?
See, the thing is that it varies from the startup. If you're filing as a startup or if you're filing as a company, it varies. But I think it is 8,000 for the startups. Hello.
Okay. And one more question I have is, like, is there
Yes.
any online platform available from which we can get complete guidance of patent filling?
I wouldn't recommend that, Avni. So there are a lot of blogs and a lot of videos which can help you to file a patent, but then I wouldn't recommend that because when you take help from a professional, they really analyze your invention and they understand what is that you have created, and accordingly they advise you, so I wouldn't recommend going to any online sort of a platform for that, because there's a lot of money involvement over there, a lot of money, a lot of your time and effort, right?
Okay, ma'am. Thank you, ma'am.
Yeah.
Okay, so any other question? So I have a question on the behalf of the audience, ma'am. If somebody wants to file a patent, but he or she wants to check that whether the particular patent is already filed or not. So how to check that?
See, you always have, there is, like I said, the first step, the prior art search that is conducted. You can do a public search that is available on the government website. You can do a patent search to see if there is any patent existing by using the key terms. Okay, you use the key terms and you get the list of inventions that are already there associated with that keyword. Okay, that is done. But it is always, like I said, it is recommended that a professional conducts that search, because this search is very intricate and very technical, right? So a person who's well versed and experienced in doing this will be of much of a help conducting this search. Yes, but there is a platform, there is a government the government website of IP India. You can conduct a public search over there. Yes.
And one more question, ma'am. So if
Yes.
someone, a student from the pharmacy, suppose, want to pursue a career in IPR, so what are the guidelines for that?
Okay. So firstly, if you want to, so for patents, basically, you need to have a science degree. Okay. So that is the basic criteria of writing a patent agent exam. So the qualification criteria is a science degree, and then there is a patent agent exam that is organized, I think, every year. So once you clear that, you become a patent agent. Okay, and then after that you can draft and you can practice patents. But then if you want to go for hearings and if you want to prosecute yourself in the if you want to prosecute in the court, then you need to be a lawyer for that. So after that you can do an LLB for 3 years. Yes.
Thank you so much, ma'am. So
you.
I think we don't have any more questions to ask. So on this note, on the behalf of Institute of Pharmacy, I extend a hearty thanks to you, to our guest, and to all the people who have patiently listened to our session. I thank respected Principal Sir and Vice Principal Sir for their guidance. I thank my colleague, Mr. Kunal Yadav, for support and guidance, and I thank all the faculty members and students to be here and part of this session. Thank you so much. The link of the feedback form and the link for the quiz will be shared here, as well as on the official WhatsApp group. So you all can go there and do the formalities further. And I wish all of you a happy World Intellectual Property Day today. And I hope that this session, which was conducted by Reddy ma'am, will be very helpful for all of us. Thank you, ma'am.
Thank you so much. Thank you.
Thank you for joining the session. Students can fill the feedback form and they can begin with the quiz also. Thank you.